Besides all the picture-perfect moments of love and happiness, marriage creates special rights to property, the most significant being the home that a married couple chooses to build the foundations on. In today's video, I'll be going over the laws surrounding matrimonial homes and why they're viewed as a unique type of property. Hey guys, if you're new to this channel, my name is Chris Chu and I'm a real estate lawyer here in Toronto. On this channel, I'll be sharing some information, tips, and insights about real estate law here in Ontario so that you can feel better prepared when tackling your next real estate transaction. So before we get into the video, I'm obligated by the Law Society of Ontario to let you know that all the content on this channel is for informational purposes only. Nothing on this channel should be construed as or replace legal advice, and the content on this channel does not form the basis of a lawyer-client relationship. Well everyone, it's Valentine's Day, and what a better way to ruin the romantic vibe than to talk about law. Ontario recognizes marriage as an economic partnership, and most family law issues are governed by what's called the Family Law Act. According to the law, the value of all property owned by either spouse is shared equally on the termination of a marriage, subject to obviously certain exceptions. Now, a matrimonial home is defined as every property that is owned by a person and is ordinarily occupied by a person and their spouse as their family residence. So before we get any further, it's important to first point out that the laws surrounding matrimonial homes apply to married couples only. That means that common law couples living together don't have the same rights and responsibilities. Secondly, the definition of a matrimonial home is wide enough to include more than one piece of property. So if a married couple splits their time between a cottage and a home in the city, both of those properties are technically regarded as matrimonial homes. Now, if a home is purchased only by one person, but it's considered a matrimonial home, the spouse of the owner has two specific rights: the right of equal possession and the right of control of the disposition and encumbrance of the property. In practice, what this means is that a person who is a spouse but is not on the deed as the owner has the right to equally possess the home and cannot be kicked out of it. I guess that's better than sleeping in the doghouse? More importantly, if there are plans to sell or refinance the home, the spouse who is not on the deed must consent before the deal can proceed. So let's look at an example where this can impact certain decisions. Let's say Luke bought a home prior to getting married to Cindy. The deed only lists Luke as the owner, but since they both live in the home, it's designated as a matrimonial home. If Luke and Cindy get into a huge argument one night over, let's say whose turn it is to wash the dishes, Luke can't tell Cindy to pack her bags and get out simply because he owns the place. Quick side tip, if you're getting into arguments about who's doing the dishes and you're trying to kick another person out of the house, probably not a good start to a relationship. Now, more importantly, if Luke decides to sell the home for a big profit, before the sale can go any further, Cindy has to be notified of the decision and allow it. Also, Luke can't get a mortgage or grant a third-party property rights without first having Cindy give the go-ahead. The intention behind these rights is to ensure that the owning spouse can't unjustly benefit from owning the property or throw the other spouse under the bus. So let's get back to our example. Say Luke wants to sell the matrimonial home and pocket a hefty amount behind Cindy's back. Or Luke plans to get a second mortgage so he can use that cash to buy, something ridiculous like a Ferrari or a motorcycle without telling Cindy. Man, Luke sounds like a huge douchebag. In the worst case, Cindy could be left without a home if Luke sells the place and runs off. Likewise, if Luke totals the car and is still responsible for the mortgage, their home is now saddled with additional debt that isn't even Cindy's problem in the first place. Now, you may be surprised to know that the general rule for spousal consent can be waived in certain situations. Firstly, if the spouse who isn't on title waives their rights by signing a separation agreement or what's called a prenup. Secondly, if there's a valid court order authorizing the transaction without having the spouse consent to it. Third, if another property is registered with the government as a matrimonial home. Now in this scenario, basically spouses can choose to officially register a specific property as a matrimonial home. While they don't have to at law, they can technically do this so that if they have more than one property that they ordinarily occupy, let's say for example a cottage property and a home in the city, they can use this to exclude one property or a bunch of other properties as matrimonial homes so that only one can be designated as one that needs spousal consent. So to sum up this scenario specifically, in this instance, the properties that are not specifically designated as matrimonial homes in the government registry system will be able to be dealt with without the other spouse's consent. Now, this can be done for a variety of reasons, such as tax planning or marriage contract planning prior to being married. So, when it comes to matrimonial homes, it's important to take some time into speaking with your spouse to assess what rights and responsibilities are allotted to each person. You may consider speaking with a family lawyer as well to ensure that each person understands their rights should the relationship turn sour. Hopefully it doesn't. Now, as a real estate lawyer, one of the first things we ask clients to do when dealing with matrimonial homes is to ensure that either their spouse is aware and has consented to the transaction, or provide some form of proof as to why consent is not necessary. Having these items checked off ahead of time can help speed up the process and make life a lot easier. Remember, timing is everything. That means that if you own a matrimonial home but your spouse isn't on title, you'll need to get their approval either to sell or mortgage the place well in advance to manage timelines like meeting with agents and brokers. And if your spouse refuses because you didn't let them know until after you put up the place for sale, you could be sued by potential buyers that hinged on their offer for you to sell the place. Now, in most cases, since the consent of the non-title holding spouse is necessary, they're going to most likely need separate legal representation, either in the form of independent legal advice or, in the case of extremely complex property transactions, total separate legal representation. That's going to be an additional factor to consider when managing timelines and costs, and it's also important to consider since you should probably keep your spouse in the loop consistently so that the flow of communication is maintained during a transaction and you're not getting yelled at by your spouse. That's it for me, guys. Thank you so much for tuning in. I hope you found this video helpful. If you did, make sure to hit the like button to subscribe. And I've also put a link in the description below to a blog post that I wrote about matrimonial homes, so hopefully you found that helpful. And as always, if you're looking to get in contact with me, you can set up an appointment via my firm's website, which I've also put in the description below. Until next time, guys, take care, and I'll see you soon.